Good day, Crime Talk aficionados. I'm back. First on the docket today, Bryan Kohberger goes to court, says all that evidence against him should be thrown out. Next, ladies and gentlemen, this is a scandal. The former star DNA expert who testified in thousands of DNA cases in Colorado, she's been arrested and charged with falsifying evidence. Richard Allen outlines why he should get a new trial. We have this day in legal history, and our dumb criminal of the day should be called Dumb and Dumber. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. So I'm sorry, wasn't available the last couple of days. Had some travel and just some court matters that took a lot longer than I thought they were going to do. So I apologize, but let's get to it. But before we do that, let me remind you to go to crimetalksearch.com. I cannot tell you how imperative it is to check people out that are coming into your life. See what they are doing, what they have done in their past. When you do a background search, you literally have the results emailed to you while you wait for the results. It's going to give you a complete background history on the individual that you are searching. It's going to include social media presence, email addresses, phone numbers associated with people, criminal history. Are they married? Are they divorced? You can get into nitty-gritties as to what kind of car they drive, ladies and gentlemen. Go to crimetalksearch.com. You're going to be happy you did. All right, let's go ahead and open the record for January 23rd, 2025. Can you believe, ladies and gentlemen, the month is almost over. Goes by so fast, doesn't it? Well, let's talk about Bryan Kohberger. He would like all the evidence against him to go away. Why? Because it's damning. It's prejudicial. If it wasn't evidence that hurt his case, his attorneys wouldn't be asking for it to be suppressed. So the judge presiding over the Kohberger matter, Mr. Judge Stephen Hippler, Wednesday denied Bryan Kohberger's request to unseal the briefings and hearings on the investigative genetic genealogy and the defense disputes in the Idaho student murder case. Now, as the state point out, there's no dispute. This is a high-profile case, particularly in Idaho. It was transferred to Ada County from Latah County on the defendant's motion to change the venue. Now, the defendant argued in their motion that the small size of the jury and the extensive inflammatory media coverage prevented him from receiving a fair trial in Latah County, while Ada County has a much larger pool to pull from than Latah County. The state is concerned that the risk of exposing the jury pool to evidence, particularly evidence that may not be deemed admissible at trial, remains significant. Now, that was one of among 12 motions to suppress filed by Kohberger's defense team that are being heard today. Now, the first part of the hearing was, it was private. They just, at the time of we started this video, came out and now is streaming. But we'll have the whole hearing for you if you can go watch that yourself if you would like to. We'll certainly talk about it more tomorrow. So this is the first time Kohberger's back in court in the last 2 months since his last court appearance. And the defense team is also asking the judge to sanction prosecutors over inadequate disclosures through the discovery process. And in particular, Bryan Kohberger did not appear in person at the closed-door hearing earlier this week. Now, his defense team is attempting to have nearly all the evidence collected by police against Bryan Kohberger thrown out by challenging the legality of the search warrants. The defense is arguing that the probable cause on which the search warrants were based was established primarily by the police using this investigative genetic genealogy, which the defense believes amounts to a violation of Kohberger's Fourth Amendment rights. Now, these are the sorts of decisions that really help determine someone's guilt at trial, all right? They attempt to keeping out as much evidence as they would, but the evidence may not be successful. But the DNA evidence comes through the jury. It's going to be a bad idea. It's going to be a bad day for Bryan Kohberger. Now, there may be lots of other things we don't know about, but like I said, as a defense attorney, you look at your case and you say, what is the bad evidence? Is it my client's confession? Is it the DNA evidence? How do I make this go away or completely counter it? Well, the defense here in Kohberger's case saying, we've got to make this DNA stuff go away or we're screwed. Ladies and gentlemen, trust me, I'm a defense attorney. All right? I'm telling you straight. This is a problem. Some people dismiss it. Oh, it doesn't really matter, right? It's just a little bit of DNA on that K-bar sheath, right? Just a little bit. It doesn't take much. But I'm telling you, all these things that the defense is trying to make go away is because they're bad for the defense, all right? Now, this investigative genetic genealogy is relatively new, and police, in this case, tried to build a suspect's family tree by comparing the DNA found at a crime scene to a public database filled with voluntary submitted DNA from people trying to learn about their ancestry. But the DNA recovered on the knife sheath at the scene is likely the most damning evidence publicly revealed against Bryan Kohberger. Like I just said, not good. And then we got the cell phone records certainly make it look bad as well. Although the fact that the phone was turned off just coincidentally at the time of the murders, that's a problem. But the DNA is going to be the big one. The other point his defense attorneys are arguing is the search warrants were overly broad, notably during the searches of electronic devices like Kohberger's phone, laptop, and online accounts. I'm sure they were, and they will be denied. Unfortunately, that's just the way the judges do it. They let you search the entire phone. How is that not a general warrant in the violation of the Fourth Amendment? I don't know, but they get to go looking and they get to go rummaging around, and then they're going to use everything against you. Now, the hearing is also going to discuss the motion to compel discovery, where Kohberger's defense attorneys argue that all the reports, research, and data on which expert prosecution witnesses will rely for their testimony at trial have not been turned over, and they're probably not going to get it. More than likely, if you have an expert witness that has 30 years of experience, he's going to say, I'm going to rely upon my 30 years of experience. Can he say it's just like this particular case? I don't know. If he's relying on a particular journal, yes, they should be able to say that. But more than likely, a judge is going to say, if they have this information and they're saying they're specifically relying upon it, they need to turn it over. But if it's their general knowledge and experience in this field, how can you make them turn over every textbook, every article, every case that they've ever relied upon? Well, it's just not going to happen. Now, the court has also set aside Friday for any other business if they don't get done today. The bottom line is, ladies and gentlemen, listen, we give Bryan Kohberger the presumption of innocence. My guess is all these motions are going to be denied. The court's going to find the searches weren't overly broad. It's going to find there's probable cause. And what standing does Bryan Kohberger have as it relates to the genetic genealogy of someone who voluntarily gave up their DNA, and then they create this family tree, and then they create a profile, and then they say, based upon that profile, based upon basically public information, we think it could be this guy. And then they go get a warrant for that guy, and then they get another warrant to get his DNA to see if it matches the DNA on the K-bar sheath button. I don't see that there's anything, no, don't get me wrong, I don't think there's anything illegal about it at this point. I don't like it. I would not give up my DNA to any of those genealogical people because you don't know who they're going to share it with. You don't know who's going to come in and look at it. So I get it. I think it's, the privacy issues, but, people don't read that little fine print when they click on those types of things, and they let their DNA be known to the world. But I don't think that the judge is going to find any illegal government conduct on that. Speaking of DNA, though, let's talk about Missy Woods. All right. Now, I've personally had many cases over the years with Missy Woods, Yvonne Missy Woods, but she goes by Missy. Well, and she was the former top Colorado Bureau of Investigative forensic scientist. She's the one that would always come to court and testify as the DNA results for this CBI. And she testified in thousands of cases over her 30-plus years at the Colorado Bureau of Investigation. Now, most people don't remember this, but I do. There was another situation for Colorado Bureau of Investigation where the woman who did all of the court testimony and supposedly testing for blood results in DNA cases, well, they were fudging the paperwork on that 2 years ago, and it resulted in a bunch of cases being thrown out. And I believe that woman also retired. But here in the case of Missy Woods, guess what? We're talking DNA, where people went to prison for long, long time, ladies and gentlemen. Anyway, now she, the hunter, becomes the hunted. All right. That's right. Missy Woods was booked into custody last night on a complaint and information alleging 102 counts in the felony indictment. All right. Not good for her. She had a $50,000 cash bond originally, but the bond was modified this morning to make it $50,000 cash or surety, which means she could go to a bail bondsman to try to get out, usually post 10%. So, $5,000, but she got to have security. She also had to turn over her passport as well. So, like I said, she appeared in court this morning. She's next scheduled for a preliminary hearing in a date to be forthcoming. Now, in the 35-page indictment, Miss Woods, who goes by Missy, faces felony charges that include attempt to influence a public servant, perjury, forgery, and cybercrime. Now, the district attorney, who's prosecuting the case, said in a statement that the Colorado Bureau investigation estimates Woods' alleged years of misconduct has now cost them roughly $11 million that the taxpayers are going to have to pony up, more than likely not to have all this stuff retested, but to do the trials all over again. Now, the former forensic DNA analyst has been at the center of this massive scandal after it was disclosed in November of 2023 that once revered scientists had deleted data, skipped steps, manipulated DNA evidence in more than 1,000 instances over her 30-year career, ladies and gentlemen. There's been a long speculations that Woods could face criminal charges as the scandal unfolded over the past year, but it was unclear until now what those charges actually would be. Now, the South Dakota Division of Criminal Investigation reviewed all of her cases that she has done for more than a year to determine what, if any, criminal charges should be brought against her. Based upon the available facts and after careful legal analysis, the prosecutors have filed charges and will now proceed with the criminal prosecution. The district attorney up there in Jefferson County says that her office will remain committed to reviewing all affected cases within their jurisdiction on behalf of the defendant and victims involved. Now, in the fall of 2023, an honest intern in the CBI lab reported suspicions that Woods was manipulating data, which prompted an internal review of Woods' work going back to about 1994. It was later revealed that the agency then, that her work had been flagged to supervisors back in 2014 and 2018. None of those instances were ever reported to the public, and Woods was permitted to continue to do her work. Gee, do you think a defense attorney would like to know that, the Colorado Bureau of Investigation knew of the faulty, shoddy work of their lead forensic investigator, and they allowed it to go on? How is that not Brady material? How should that not be turned over, ladies and gentlemen? Now, of course, how many you would say, well, Scott, surely somebody has been fired, right? No, Missy Woods was allowed to retire, and nobody has been fired thus far. Now, for much of the career, she was considered the state's go-to expert, and I can attest to this, ladies and gentlemen. I've had many cases with her, and we've had cases where we tried to say there were issues. Everybody poo-poos you. How dare you question the impeccable Missy Woods? She's just a scientist. She's not out there doing anything. She has no dog in the fight. No, she thought that she was a member of the prosecution team, and she was there to get the guy, including apparently, allegedly, she would falsify her work to get the results that she wanted. Now, that's not very scientific now, is it? That's not very impartial now, is it? The Colorado Bureau of Investigation said that she had worked on more than 10,000 cases during her 29-year time employed at the Colorado Bureau of Investigation. And like I said, she was allowed to retire in 2023, just before the scandal broke. How convenient. Now, she has no prior history, which is good, because it was been covered up, all of her alleged misconduct. Now, a Colorado Bureau of Investigation spokesman had no immediate comment. And as of late last year, CBI acknowledged it had uncovered 1,003 anomalies or irregularities in roughly 10% of all of her work. Now, CBI has continued to say that its internal investigation did not show that she had ever falsified DNA matches or fabricated profiles. Just make a couple rounding errors to make it just stick strong enough, I guess. Anyway, so this little scandal has thrown the fate of an undetermined number of criminal cases into limbo, not only upsetting prosecutors and defense attorneys as well, but think of all the families where they may have to go through all this all over again and be re-traumatized by a trial. There's obviously some deep concern that defendants may have been wrongfully imprisoned based upon her DNA conclusions and testimony, but also prosecutors in at least 3 cases so far have felt forced to offer reduced charges and lighter sentences to murder suspects once headed for trial as a result of the work of Missy Woods. Now, just last week, the case against the suspect murderer in a Douglas County case dissolved into a plea deal because neither prosecutor nor defense attorney wanted to risk going to trial because of Woods' original DNA analysis in the case and the lingering cloud over the Colorado Bureau of Investigation. Now, in that particular case, Roger Dean was killed during a botched robbery at his Lone Tree home back in 1985. The case had gone cold until Woods' analysis of DNA found some DNA on a ski mask and led to the arrest of a guy by the name of William Jefferson, who had been held in the Douglas County Jail since 2021. Anyway, Jefferson faced life in prison on a first-degree murder charge, but District Attorney George Brockler said last week he felt he had no choice but to offer Jefferson a reduced sentence of 32 years on a single count of conspiracy to commit first-degree murder rather than take the case to trial. Jefferson's defense attorney stated that the scandal enveloping the CBI should not be the end as it relates to Miss Woods and her arrest. His attorney said it's hard to have faith in anything they do at this point, especially since they seemingly didn't know what was going on. A little remarkable that they dropped the ball on this completely. And when you're talking about the public trusting an entity like this, how can you have faith in anything the Colorado Bureau of Investigation is affiliated with at this point? Now, throughout the scandal, Woods has said little about the allegations against her, except that she has often felt overworked. It was not unusual for her to handle a larger caseload than her colleagues in the lab, a distinction that she took it with pride. Now, during a 2023 interview with investigators about the suspected wrongdoing, Woods remained vague in her responses, saying she didn't remember specific incidents or said, well, it's a possibility. You literally can be the person who works to bring down CBI, the forensic services. One of the interviewers told Woods during that time, says, obviously, everyone's biggest fear is that somebody might actually be in prison that shouldn't be there. Like I said, there's another case out of Boulder, Colorado, where an individual is serving a sentence of life without the possibility of parole, which he says he did not commit. And in that particular case, a guy by the name of Mr. Clark was convicted in 2012 in a long dormant case, largely on the strength of DNA analysis conducted by Miss Woods. That analysis has since been disputed by an outside DNA expert. And after the scandal broke, the district attorney there in Boulder asked DNA in the case be retested. Now, that hearing is scheduled for January 30th, and Clark's defense attorneys have asked that his client's conviction be overturned. Now, Missy Woods is personally responsible for the ongoing nightmare of Mr. Clark's wrongful conviction, the attorneys allege. I'm telling you, ladies and gentlemen, this is scary. And you hear about, remember the case in Boston where the lab tech, she was the best one, she was the fastest, she did all the great work, falsified drug results, and they threw out thousands of cases. Here, as it relates to Missy Woods, this is significant. Now, like I said, you got to give her the presumption of innocence, but she has 52 counts of forgery here, 48 counts of attempt to influence a public servant, 1 count of first-degree perjury, and 1 count of cybercrime. Like I said, 58 instances of criminal misconduct that touched jurisdictions across the entire state, all the way down south in Pueblo to up north in Fort Collins, Gilpin County, and Aurora, Denver, and Boulder. Now, there's one case that was also a federal case that she cooperated on, and is obviously things broke. It's been long coming. Like I said, we'll give her the presumption of innocence, but ladies and gentlemen, I'm telling you, the testing is only as good as the people that are doing it. I know they can say, well, they plugged it in the machine, but all that stuff is usually quite subjective if it's a close call, and how they determine what it is. And the way that they interpret DNA analysis has changed so much over the years. It's statistics. It's just statistics, and what the numbers always make it sound like isn't necessarily what they mean. And I was talking just briefly before we started this video, and I had a case years ago. It was a homicide case, and we had issues with the DNA. And the judge wouldn't allow us to do this, but we had an expert witness said, man, there's contamination. Something's not right. Something's not right. Our expert said, there's something not right, but I need the information. Everybody poo-pooed our request to get all of the information at the time. And needless to say, client went to trial, got convicted. It was a horrible case. And then literally 5 years later down the road, I get a letter saying, oh, we were doing this audit because, all the certifications that they do to say, how dare you question our lab and our integrity because all of the certifications that we have and accreditations. And, well, somebody was doing something and they came across an error. And they said, guess what? That sample that you were talking about that you thought there were issues with, they wouldn't even let us cross-examine at trial because how dare you question the crime lab? Look at all their accreditations. Look. Well, it turns out there was contamination. One of their DNA technicians somehow got his DNA into the sample. But yet we were the ones that were being stared at like we had a third eye sticking out of our forehead. And, how dare you question it? How dare you do that? And then we got to get a letter saying, oh, by the way, do over, right? So, yes, DNA is powerful stuff, but you got to make sure it's done correctly, and you got to make sure they're not fudging the numbers. Like I said, it's statistics, right? There's lies, damn lies, and then there's statistics. That's probably what they meant when they were talking about that. I know that goes way back, but the reality of it is that's what it comes to when you're talking about DNA evidence. So, trust but verify, be cautious indeed. Next, Lori Vallow. That's right, convicted killer Lori Vallow. Been doing some pro se motion filing in her case down in Arizona. Obviously, she faces charges in her murder of her fourth husband, Charles Vallow, and conspiring in an attempt to kill her niece's now ex-husband, Brandon Boudreaux. Now, the two cases in Arizona are being tried separately, and Vallow is scheduled to stand trial for Charles Vallow's murder first. Now, jury selection is that case is scheduled to begin on March 31st, and Vallow, who told the judge that she no longer wants to use the name Vallow and solely wants to be known as Lori Daybell in court. Well, she'll always be Lori Vallow to me, all right? I'm not going to give her the satisfaction. She's Lori Vallow. The world should know her as Lori Vallow. Don't try to hide behind a new last name, because that husband, was convicted of killing the three people that you are also convicted of. Anyway, the motions that she filed are in regards to speedy trial. Now, the law in Arizona is that the speedy trial right is 150 days, or in a case that has been declared complex, there's 270 days in which to get the defendant to trial. Vallow has never waived her right to speedy trial, she maintains, and that waiting until the completion of the murder trial to face the second case violates that right to a speedy trial. Now, normally what happens is, for example, in the federal system, speedy trial starts from the time that you're indicted and or arrested, normally within a short period of time. In some states, though, it doesn't really begin ticking until you actually say not guilty. So you may say, when you have multiple cases, you say, Judge, let's handle the first homicide case. And, depending on how that goes, then we'll deal with all these other cases. So we're not going to enter a plea. So speedy trial is not running at that particular time. because you want to see what happens to the first case, right? If she goes down in the first case, they may not go forward on the second case. But she's saying, hey, let me out because too much time has passed. I want to go to trial. But I don't think she's ever entered a plea of not guilty in that particular case. Anyway, Ms. Vallow says the state of Arizona has had plenty of time to figure this out. The state has never been willing to combine these two charges into one trial. Why did they not schedule two trials at the arraignment? Why did the state arraign the defendant for both cases on the same day, knowing they could not provide two separate speedy trials? Now, a second motion accuses the state, specifically the prosecutor, of interfering with her right to gather evidence for her defense. An email reportedly from Kay to Vallow defense team was attached to the motion, purportedly referencing a public records request to the Gilbert, Arizona Police Department, wherein Kay said in the email, in the future, will you please make all requests for additional discovery to me? I am happy to facilitate the disclosure of relevant discovery. Vallow has requested an evidentiary hearing and copies of all communications between the prosecutor's office and the Gilbert Police Department. Prosecutors have not yet filed their response to the motion, but it's going to be clear that I believe they'll have a different set of calculations as it relates to Lori Vallow's request for a speedy trial. Next on the docket, Richard Allen's attorneys laid out why he should get a new trial. Attorneys for convicted Delphi murderer Richard Allen filed a plenty of documents this week suggesting that their client's murder conviction, should be thrown out, vacated. The 24-page motion to correct errors, according to Allen's defense team, takes aim at the murderer's timeline, the validity of Allen's safekeeping order, a purported confession from a different suspect, and a disputed phone number and evidence. So on November 11th, a jury convicted Richard Allen of murder in the February 2017 deaths of Abby William and Libby German near the Monon High Bridge there in Delphi, Indiana. The special judge, Judge Francis C. Gull, sentenced Mr. Allen to 130 years in prison on December 20th. Now, his attorneys have maintained their client's innocent and have hammered the state on procedural issues throughout the duration of the case. Obviously, they're planning to an appeal, but they're making their final attempt at the trial court level. One was the safekeeping order. The attorneys note that Allen was arrested on October 26, 2022, after being questioned by the Indiana State Police investigator, Jerry Holman. Allen was held in a jail under a pseudonym for his own protection. On October 27th, his wife hired an attorney by the name of Brett Gibson to represent Mr. Allen. Gibson tried to contact Allen by phone, but was told no one under the name was at the jail. He was then contacted the Carroll County prosecutor, Nick McClelland, who arranged for Gibson to meet with Mr. Allen. About 10 p.m. on the 27th of October, Gibson advised Allen's wife that he could not get Allen out of jail because he was being charged with murder. Allen was then moved to the White County Jail. Allen mailed a letter from the jail on November 1st of 2022 stating he couldn't afford an attorney, although the letter wasn't filed until November 9th. The defense said the safekeeping order that placed Allen into custody of the Indiana Department of Corrections was plainly illegal. And they said Allen was being held in the White County Jail while Toby Lesenby, the Carroll County Sheriff, requested the safekeeping order. But the White County Sheriff, the defense contends, and not Lesenby, had the authority to request the safekeeping order. In their view, the Carroll County Circuit Judge Benjamin Diner lacked jurisdiction to approve Lesenby's request for this protective order. The defense has also argued that Diner, who had approved the search warrant for Allen's home in October, assisted the sheriff in drafting the safekeeping order and should have recused himself. Now, Allen had the right for another judge to review and issue the safekeeping order. The attorneys claimed several procedural deficiencies with the safekeeping order and said that Allen had an absolute right to refuse being transferred into state custody. The attorney said the safekeeping order wasn't served to Allen or Gibson. the attorney his wife had hired, and thus neither Allen nor Gibson had the opportunity to argue against the transfer order. Allen's attorneys also argued that the state deprived Allen of constitutional rights afforded to him under the 6th and 14th Amendment. Now, one of the key pieces of evidence used against Allen at trial was a confession in which he said a white van spooked him, leading him to panic and kill Abby Williams and Libby German. The prosecution identified 2:32 p.m. as the moment when Libby German's phone stopped moving. The prosecutor, Mr. McClellan, called it a hard fact that the phone stopped moving at that moment. During a confession given to a prison psychologist, Allen said he abducted the girls on the Monon High Bridge and forced them down the hill. He claimed he was going to sexually assault the girls when he saw a white van heading down a nearby access road, causing him to panic and order the girls across the creek, where he ultimately killed them. Now, the prosecution touted the white van as a detail only the killer would know. The driver of the van, a guy by the name of Brad Weber, testified he drove past the murder scene at about 2:30 p.m. on the way to his parents' house. But the defense said surveillance video showed a van matching Weber's heading north on Access Road at 2:44 p.m. on February 13th of 2017. That meant that Weber couldn't have passed the murder scene at 2:30 and would have arrived home at a time after 2:44 p.m. Additionally, the FBI report indicated Weber's phone first pinged his parents' address at 2:50 p.m. on February 13th of 2017, reinforcing the time set out by the surveillance videos. The defense accused the state of presenting false information in court or failing to correct information that the state knew to be false. The state used Weber's testimony to corroborate Allen's confession to the prison psychologist. Now, obviously, the defense cross-examined vigorously on this, so I'm not sure that argument's going to pass muster and get a new trial. Now, if the state didn't know about the surveillance video, the defense argued, then the video would constitute new evidence. That would probably produce a different result at trial. Now, Ron Logan, the guy who owned the property where the girls were killed, in the early days of the investigation, he provided reporters with tours of the property and talked about the case and the search for the girls. The Federal Bureau of Investigation also requested a search warrant for Logan's property back in March of 2017, just weeks after the murder, and the warrant indicated investigators wanted to search his home and outbuildings for anything related to the girls' killing, including forensic evidence, digital devices, guns, and cutting instruments. That search was conducted ultimately on March 17th of 2017. The FBI agent who wrote the warrant said Logan's physical build was consistent with the Bridge Guy video taken from Libby German's phone, and his voice was not inconsistent with the person in the video. He's also concocted a false alibi. Logan was never charged in connection with the case. He died back in January 2022. Now, according to a tip from May of 2017, Logan confessed to another inmate that he killed the girls. The inmate said Logan claimed he burned his clothes in a fire pit and feared drops of blood from his nose may have ended up on the girls' clothes. Now, police followed up on that tip and interviewed the inmate, a guy by the name of Ricky Davis, at the Newcastle Correctional Facility. It's an Indiana state facility, and the state police first sergeant conducted the interview. The investigators' handwritten notes indicate Logan told Davis he was walking and talking with the girls about knowing one of their fathers. One of the girls wanted to turn around. Logan grabbed Abby's shoulder, which caused Libby to freak out. One of the girls said something about calling the police. Logan told Davis he was paranoid about a probation violation and felt like he crossed a line when he grabbed Abby. Logan asked the girls if they wanted to see some of his animals, including his horses. Libby didn't want to go. Abby was open to the idea, especially to the idea of the horses. Ultimately, this led to a scuffle, according to the inmate's account, and Logan got hit in the nose. He pulled out a box cutter and attacked Libby, cutting her throat. He said Abby was scared, and he took her somewhere, although he didn't say where. He eventually cut her neck too, according to the inmate's account. Now, Logan told the inmate, allegedly, he came back hours later and wanted to move Libby to an area where she wouldn't be found. He burned his clothes in a burn pit, boots, gloves, and a bag. The next morning, people showed up asking if they could search his property. Logan told them they could because it wouldn't have felt weird if he said no. He then contacted a family member and left the area. In a handwritten note about Logan's confession, Davis said Logan killed both girls because things went too far and they all panicked when he grabbed Abby to reassure her that things were just going to be okay. Logan's mention of box cutters is notable because Dr. Roland Kaur, the forensic pathologist who conducted the girls' autopsies, said during the trial that the girls could have been killed by a single box cutter. His initial opinion was that two different weapons may have been used in the murders. Ron Logan's confession exculpates Mr. Allen and would probably produce a different result at trial. Accordingly, the court should either vacate Mr. Allen's convictions or set this motion for a hearing. The attorneys are asking for. And then they have the headphone jack evidence. The fourth point raised in the motion concerns disputed evidence surrounding the headphone jack of Libby German's phone. During the trial, the defense called forensic expert Stacy Eldridge to the stand. She analyzed the data from logs from the phones and said it appeared someone had plugged headphones into the auxiliary jack at 5:44 p.m. on February 13th of 2017 and removed the headphones at 10:32 p.m. on the same day. This information, the defense alleges or writes in their motion, casts doubt on the state's timeline. And after learning about the state's phone expert, Indiana State Police First Sergeant Chris Cecil suggested dirt or water damage to the phone may have been responsible for the logged activity on the phone. Cecil had performed a Google search during a court break before offering his opinion. The defense said it didn't have the chance to counter Cecil's determination during the trial, and according to Eldridge, nothing on Libby's phone indicated there had been water damage. Photos of the phone didn't show the phone was covered in water, dirt, or other debris, and she was unaware of any scientific or technological research suggesting that water or dirt damage to an iPhone 6 would cause the phone to inaccurately log wired headphones in or wired headphones out. At no point during the trial did the state allege Allen return to the murder scene. Were a jury to lend credence to Eldridge's analysis, the state's narrative is impossible. The defense wrote in their motion. Now, Ms. Eldridge's opinion that dirt or water could not have caused Libby German's phone to log wired headphones being plugged into and being unplugged from the phone exculpates Mr. Allen and would probably produce a different result at trial. Accordingly, the defense wants Mr. Allen's case thrown out. Now, before an appeal is filed in lots of states, the defense has to file a motion for a new trial. We don't require that here. You can, but you don't do it generally, unless you think there's clear error in this particular case. Now, I get the defense laying some groundwork for the public, the appellate attorneys, the appellate courts in the future. I get that. But most of this stuff is information that the jury knew about, considered it, and they still found Richard Allen guilty. And given the track record of Judge Frances C. Gull, I find it highly unlikely that she is going to give a new trial to Mr. Allen. She will promptly deny this motion. Next, this day in legal history. That's right, January 23rd, 1789, Georgetown University. That's right, the first Catholic and Jesuit institution of higher education in the United States was established in Georgetown, Maryland, which is now technically part of Washington, D.C. Now, the founding of Georgetown University marked a significant development in U.S. education system, promoting religious and academic freedom. And then on this day in 1964, ratification of the 24th Amendment. That's right, the 24th Amendment to the United States Constitution was amended in 1964 and ultimately ratified, prohibiting the use of poll taxes in federal elections. This amendment eliminated a significant barrier to voting for many low-income and minority citizens, strengthening the democratic process and advancing civil rights. So just quickly, the 24th Amendment, Section 1, Section 2, the right of the citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for Senate or representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay a poll tax or other tax. The Congress shall have the power to enforce this article by appropriate legislation. Well, you may say, gee, Scott, how did that happen? Well, generally, the states were given the rights to make the rules of who could vote. And many states had restrictions that you had to own property. And because their thinking was that if you own property, then you would have more significance in voting. But it was probably just a way to keep the poor people who didn't own property from voting. Anyway, then they changed the law a little bit, and they said, well, you can still vote, but you may have to pay a tax, like 1% of what everybody else would have to pay, since they're paying taxes and you're not. That's the way they looked at it. And then, of course, they came up with other things that were known to be poll taxes, like, gee, how many jelly beans are in this jar? Oh, you got it wrong. Can you pass a literacy test? So those have all been determined to be illegal poll taxes, although called by a different name. So, 1964, ladies and gentlemen, that all changed. Next on this day in legal history, in 1973, the announcement of the Vietnam War Peace Agreement. That's right, President Nixon announced that the United States had reached an agreement to end the Vietnam War, leading to the signing of the Paris Accord. Obviously, that was with the withdrawal of U.S. troops and had a lasting effect on U.S. foreign policy and military engagements. That was the beginning of the last time we've really won an actual war. We don't declare wars. We just have military incursions, conflicts, police actions. Anyway, we'll just leave it at that. And finally today, our dumb criminal of the day. Dumb and Dumber is what we should call this today, ladies and gentlemen. A dispute over cold French fries at a Wendy's in Kentucky erupted into an exchange of gunfire between the male patron and the female restaurant employee who was shot in the butt. Anyway, both have been arrested. So police allege that Monjah, M-O-N-J-A-H, Monjah, common spelling, James Wooten, and his associates engaged in a verbal altercation at the drive-through window with Twanisha, T-W-A-U-N-E-S-H-A, once again, common spelling, Coleman, a 26-year-old Wendy's worker, regarding their fries because they were cold. Apparently, James Wooten and his co-defendant subsequently entered the restaurant where he allegedly produced a firearm and fired a shot. Well, Miss Coleman, not to be outdone, returned fire because she was apparently packing heat herself. Anyway, then the other defendant began firing multiple rounds at each other, which struck the victim in the buttocks. Now, a day after the incident, a second woman contacted the police and reported that she too had been shot. She just didn't bother to stick around because that's normal. Anyway, the woman reportedly admitted that she had been with James Wooten at Wendy's when he shot her. Now, charged with felony assault, James Wooten turned himself in to police last Friday. He's being held at the Louisville Metro Department of Corrections. Now, Miss Coleman, the Wendy's worker, is facing serious problems of her own at the time because, why? She was on probation for a felony. And felons can't possess firearms, particularly when you're on probation. That's right, possession of a weapon by a previous offender. Anyway, Miss Coleman pled guilty back in 2022 for possession of a firearm by a convicted felon. Clearly, that message is getting through to Miss Coleman. Anyway, as a result of the incident, Miss Coleman has once again been charged with being a felon in possession of a firearm. She is going to have court again on February 4th. It's unclear if Miss Coleman will face a probation violation in court. Yes, she will. Okay, you're on probation. You pick up a new charge, a petition to revoke your probation will be filed, and you'll probably be arrested on that case too. Not looking good for either one of them. They are both dumb criminals of the day, Dumb and Dumber. Congratulations, you two. You made it. This is why we have this particular section every day, ladies and gentlemen, and there's no shortage of dumb criminals. None whatsoever. Anyway, that's all we have for you today. Thanks for joining us. Hope you have a wonderful day. And remember, the Constitution matters.